Welcome to the People's Verdict. I'm your usual host, Patrick Soko, and today we have an interesting discussion where we'll be talking to issues pertaining to wills and property grabbing. And in the studio, I've been joined by the Principal Legal Officer, Mr. KATELE M. KALUMBA, and a Senior Examiner and Estate Officer, Mr. TITUS MITI. Together we'll be with you up to the hour of 8 to discuss various issues pertaining to the Ministry of Justice, especially on the subject matter addressing issues pertaining to wills and property grabbing. These are quite common incidences that happen in our communities, but how do we go around them? How do we understand how to manage these issues is our topic of discussion today. Welcome to the program, gentlemen.
Thank you. Thank you for having us.
Interesting. And to just get our discussion going, we want to first of all understand what is the Department of the Administrator General and where it is located, because this is where everything falls, especially pertaining to our topic of discussion today. Okay.
The Office of the Administrator General is an office created by statute, particularly the Administrator General's Act. It's an office that falls under the Ministry of Justice. So it's a department under the Ministry of Justice, although it also enjoys the unique quality of being what you would call a corporate soul in legal terms, but basically a body that can sue and be sued in its own name and that kind of thing. But really, over and above, it's a department under the Ministry of Justice, created by statute, and it's an office that is created as because one of the core functions, of course, is the administration of estates, and as you see inherent in the name, the Administrator General. So in deceased estates, you have an administrator that would administer an estate, who could be any individual, maybe it's a family member or so on and so forth. So the Office of the Administrator General is kind of a big brother, if you will, to administrators in Zambia, because they do also carry out the function of administering estates. It's an office that is located Kent Building. Kent Building, I believe, has there are two buildings within the premise of Kent Building. One of them, I think, you have the Immigration Office. It's actually what you would call New Kent Building. And it's on the second floor of New Kent Building. That's, I think, right between the High Court and the Intercontinental Hotel.
Interesting. Now, Mr. Meet, I know he has touched a part to it, but I also want you to also explain what are the core functions of the Administrator General and the objectives, to be specific.
Yes. Initially, just like my colleague has said, yes, the Administrator General is not a new office. It was established sometime in 1925. That was meant to cater for the white settlers who were in the southern Rhodesia and in northern Rhodesia. So the core functions of the Administrator General really are to administer estates of deceased people. These are persons who die tested, meaning they prepared a will, what should be done to their property once they die, or people who did not prepare a will, died intestate, leaving no will. So that is one of the duties of the Administrator General. Yes. The Administrator General also deals with matters of bankruptcy. Yes, the Administrator General, initially in the Bankruptcy Act, is supposed to act as an official receiver. Yes, there were also other many duties, but we have been linked because the Administrator General was originally Administrator General and official receiver. So it used to operate in two sections, but now these have been separated. The official receiver operates on its own, but it is the same person who is the Administrator General, acts as the official receiver of liquidated companies.
Interesting. But Mr. KALUMBA, who are the clients, especially over the department, and who can access the services of the Administrator General? Is it everyone, if for instance myself, or it should be companies?
Well, obviously you will be dealing with natural persons like you and me, and as far as who accesses the services of the Administrator General, the Administrator General basically is a public office. So the clients, if you will, are members of the general public. Anyone who is in the situation where they need our services. When we talk about deceased estates, you mentioned companies. We may not really go too much into detail about that aspect, but I think you may have, Mr. MITI just touched on the other function that we carry out, which is we double as the official receiver. And in that regard, of course, we are dealing with companies, defunct companies, and so on and so forth. But I believe the object of our discussion right now is on the aspect of administering deceased estates. So as far as the clients, to answer your question, we're talking about basically the public at large. So there is now a provision in the law that categorizes what kind of persons we're talking about, and therefore any individual could come to our office with a problem for us to give advice and so on and so forth.
Interesting. Now, Mr. MITI, I also want to lay in, especially on this very aspect where we have witnessed in most cases when a person dies, members of the family would appoint themselves as administrators of the estate. But according to the law, who qualifies actually to be the administrator?
Yes, according to the Intestate Succession Act, when a person dies and leaving no will, persons to administer estates are periodic dependents. So periodic dependents are the surviving spouse, children, and parents, and dependents. So in that sequence, the first people to be appointed administrators are children of that deceased person, the surviving spouse, the parents, before they consider other remote or near relatives of a deceased person. So in such situations, yes, we have seen also, we have witnessed where uncles, aunties would want to jump on and become administrators, despite the deceased having been survived by the children and the surviving spouse. But in the sequence, it is the children and the surviving spouse that have the first period to apply to court to become administrators of the estate.
Maybe just a rider to that would be, at what age do children qualify to be the administrators? Probably, let's say the surviving spouse is no more as well, but the children, is it any child of, or they have to be to acquire a certain age?
Yes, children of majority age. Majority age would mean from 18 years and above. They qualify to become administrators of the estate. Yes, so if one dies leaving children above 18 years, they equally qualify to become administrators of the estate. But where these children are minors and they have not attained that age, it means there is need in that particular estate that 2 or more administrators be appointed to safeguard the interests of the minors.
Okay,
yes.
Interesting. But they can eventually take over when they reach the right age.
Yes, if at the time they attain the majority age, the estate is not fully distributed. Yes, they qualify to be administrators of such estates. Interesting.
Now, in what circumstances now does the Administrator General administer estates of deceased persons, and who reports such cases to the office?
The Office of the Administrator General administers estates more as a last resort. The law designed it in such a way that we are not necessarily the first resort when, and I have to say this because in our practice we have so many members of the public who come with problems and who have not gone so far as to make efforts to try and get the affairs in order, you know, by administering estates. And because there's so much bickering going on between family members, the first thing that maybe comes to people's mind is, oh, we need to see the Administrator General. But the law doesn't creates the situation where we are more or less a last resort as far as administering estates. So it will be situations where, for instance, an estate has not been administered for, you know, an inordinate, you know, length of time since a person's passing, you know, maybe beyond a year or something like that, and, you know, nothing is happening. And also sometimes maybe you may have an administrator in an estate, but it has been a considerable period of time and there has been no action on that estate, or there's been no administration, or the manner in which they are doing their job is not you know, to satisfaction. Those are some of the circumstances which the Administrator General becomes an administrator. Mm-hmm. So the primary work of the Administrator General really centers around guiding family members, guiding families who have a problem. For instance, you know, there's something going on within a family concerning the administration of an estate, and there's problems maybe because the administrator is not doing his job properly, or people are not getting along, whatever the problem may be. Mm-hmm. And they come to our office. The first thing that we are trying to do is to hear them out and render advice. So what we do is more in a consultative capacity. We render advice. That's the primary function. It's only under those circumstances spelled out in the law that we, as a last resort, end up being taking over the administration of an estate.
Interesting. Well, our dear viewers, in case you were just joining us, you have not missed much because we are discussing important issues pertaining to wills and property grabbing. And in conversation, we have the Department of the Administrator General helping us discuss this issue in detail. And I have in studio the Principal Legal Officer, Mr. KATELE M. KALUMBA, and the Senior Examiner and Estates Officer, Mr. TITUS MITI. And you too, in case you wanted to contribute to the conversation, you can equally follow us on our Facebook page and leave us a message and contribute or ask your questions, and our guests will be able to respond to your concerns pertaining to the topic of discussion. And just now you wanted to also contribute something to what Mr. KALUMBA was just saying.
Yes, just in addition, yes, in what circumstances does the Administrator General come in to administer estates of deceased persons? There are cases where one could have prepared a will, and then in the will he did not name the executor of the will. In such circumstances, the Administrator General would come in, and then where one could have named a will, an executor, and that executor declined or renounced his office to become the executor of that will, we actually come in. And then the other third one is where a person died intestate and no administrator has been appointed. The Administrator General may come in such circumstances. That is what I wanted to add on.
Interesting, and that brings me to my next question, which is who are the beneficiaries of an estate when one dies without having made a will, and the distribution. So you talked about various components in terms of how the Administrator General comes in, but there's the aspect of the distribution in terms of percentages. Who is entitled to what? How do you determine that?
Well, the law spells out who gets what. This is, of course, unlike the situation where someone has died having left a will. If someone dies and we have to, of course, take the opportunity to advise members of the public who may be listening in or watching this program that it's our job to sensitize, and we wish to mention that it's advisable that people seek help if they want to, and write wills. It's something that is encouraged, because then it usually creates for a better situation, you know, in the event of one's passing, you know, as far as people disagreeing on things and that kind of thing. But that being said, when someone dies without having written a will, then the Interstate Succession Act says who gets what. So it mentions certain priority dependents, so to speak, which would be the children and the surviving spouse, and of course it mentions their respective percentages. I think children get 50%, surviving spouse gets 20%, and then it goes down the line as far as like who has less priority, from surviving spouse, children, parents, dependents, and then what you would call near relatives. So of course the percentages get less as you go down the line. Parents, I think, get 20%, and dependents get 10%, and so on and so forth. So anyway, that particular section, I think it's section 5, spells out generally who gets what as far as who is a beneficiary.
So if you, for instance, you find yourself in a situation, you've been appointed administrator, especially in our setup, then you decide to allocate contrary to what the law prescribes. Would you be found with a case to answer, provided you are reported?
That's a good question. So if you are in the position of being an administrator, and of course you having been guided by the law as to who gets what, and you do something outside of that, well, our law, I'm not sure that I don't believe our law quite spells out how you address that situation where one who has been given authority, legal authority, to administer an estate wrongly distributes the estate, or distributes to the detriment of other beneficiaries. But the English common law, which we also rely on in Zambia, does spell out what kind of recourse beneficiaries in those circumstances would have. And I think if I'm stating it correctly, a beneficiary can pursue another individual who may have wrongly received a gift, but of course this would be through, you know, maybe making a demand and eventually a court action. Yeah, but I hope that you know, that's the simplest way I can answer your question.
Exactly.
Yes, yes, yes. You know, as far as the common law is concerned, and also our only Interstate Succession Act provides that any administrator who deprives a beneficiary of his share shall be ordered to restitute to the estate what he is told, what he did not dispute nicely, and he may be convicted for depriving a beneficiary. So it equally goes to guardians who deprive beneficiaries. Also, they are liable to conviction because they need not to deprive a beneficiary of that entitlement. So it is a criminal offense to deprive a beneficiary of the entitlement under our law.
Interesting. But I'm actually getting to understand more over this department, and how can people trust that the office of the Administrator General can help him in these circumstances? How do you adhere to issues pertaining to transparency?
Yeah, it's a good question. Yes, the Administrator General, just like any other government institution, is subject to the Auditor General. The Auditor General audits the books of the Administrator General, and any resources that are received by the Administrator General are accounted for, and the beneficiaries are brought in when we are accounting to see how the monies have been distributed, and confirm and even sign that they have received such monies, and every way that is received by the Administrator General is accounted for, together with the beneficiaries in their presence.
Okay, just to add on, and this is also just to take the opportunity to sensitize the public. Where an estate is being administered by a private individual, whether it's a family member or that kind of thing, there are duties which are imposed on all administrators. Of course, the Administrator General is no exception. But administrators in general have duties. And those main duties, of course, would be, of course, to ensure that, liabilities are taken care of, things that the deceased person may have owed are taken care of before any distribution is done. Then, of course, there's a duty to distribute to beneficiaries. But coming to what we're discussing, and to add on to what Mr. MITI has just said, there is the duty to account. So that applies to all administrators. If you are under a duty to account to beneficiaries for whatever you've done, because the law empowers you as an administrator in the sense that you step in the shoes of that person who has died. That what that person owned in terms of their estate vests in you. So you are more like you are stepping into the shoes of that person. And of course that means that you have wide powers. Basically you can do with that person's assets what they could have done. So that being said, you are given these powers, of course, to be able to administer the estate, and it's supposed to be to the benefit of the beneficiaries. So therefore, if you spend one ingwe out of an estate, and any beneficiary should be able to hold you to account, to ask you to say, okay, how exactly did you distribute this? There was so much money in bank A in this account. Now it's less. What exactly did you do? If of course they were not seeing whatever it is that you did, you have to account. And in the event that a beneficiary is dissatisfied with the way an administrator is conducting themselves as far as the administration, they can of course sue, and then of course the court would impose that duty on the administrator, which is to account through a court order. Interesting.
Well, dear viewers, you are watching the People's Verdict, and as usual in this program we bring to you important national issues to discuss, and so that we can make progress together. And today we have a unique topic addressing issues pertaining to wills and property grabbing. In case you've been facing such challenges, we have the experts to help you understand these issues, and also you can ask your questions even via our social media platform. Remember, KAME TV has also diversified in terms of its coverage. We are on all social media platforms such as Twitter, YouTube, TikTok, and Facebook. You can also follow us on YouTube in case you want to get to follow the program. And just now we are going to take a very short break. I will be back on the other side. Stay tuned.
Hello, I'm Deborah Lukalu, all the way from South Africa. You are watching KAME channel, not just another channel. God bless you. Stay tuned.
Welcome back. Thank you for staying tuned. You are still watching the People's Verdict, and we continue with our discussion. And just now, I wanted to also find out, especially on this aspect of how does the department of the Administrator General secure the interest of children, especially those who are below the age of 18, in terms of ensuring that their interest is safeguarded. How does the department come in? How can even people know to say, okay, I can equally report if I have this challenge to the department so that they can intervene or assist us? How do you come in to secure the interest of children?
Yes, just like Mr. KATELE mentioned, what happens is when a case is reported to the Administrator General, yes, we were asked what type of, or who reports the cases to Administrator General. Yes, cases to Administrator General come in form of court orders. The court may appoint an administrator from the families, and if that administrator is found wanting and they have revoked that appointment, the court may order that the matter be referred to the Administrator General. Members of the public come to Administrator General to report. So once the Administrator General takes up such a case and there are minor interest, so minor interest are treated like a trust where we receive money and we start remitting to schools, to various institutions where these children are pursuing their education. So we maintain an account for these minor children. If the parents left some properties, we receive rentals. We have an account where money is deposited and we pay to the benefit of such children until they attain the majority age. When they attain the majority age, we actually vest these properties in their names, give them their titles, and then if there is any money outstanding to their account, we pay to these children, such that we make an accountability at that time, and that is how we safeguard their interest.
I also want to know if I'm accessing the services of the Administrator General, do I need to pay the department some certain money so that they can help me with my issues? Do I need to pay a certain amount?
When a case is reported to Administrator General, we equally apply to court to administer such an estate. There are fees that they are payable to court as court fees. As provided in the Act, cost to an estate cost to that estate. So it means this money is paid from the estate to meet the cost, court fees. And then when it comes to administration of the estate, the Administrator General, yes, charges a percentage of every kwacha or every ngwe received in the office, and that is 5% of the cash received as administration fees. On the properties, we render advice and we even do legal documents. So on every property that we are vesting to beneficiaries, we charge 0.5% as our fees of the value of that property. Apart from that, there is nothing else that the beneficiary pays to the Administrator General. So basically, it's 5% of the proceeds of the estate that are chargeable to the Administrator General.
If I may add on, yeah. So in a nutshell, that of course puts the Administrator General in a unique position as far as administrators in general, because with regard to administrators, private individuals, they don't get paid for doing that work. It's not a job that you get paid money for. I don't know, and this is also an opportunity to tell the public. Sometimes you have people who are quick to volunteer to become administrators because they feel maybe there's a big payday that's coming at the end of it, and they stand to benefit or whatever. It's really a thankless job, if you will. it's really you. If you are a family member volunteering yourself to administer an estate, you are really doing what's supposed to be a very selfless act. The law doesn't prescribe any benefit for an administrator. So in that regard, the Administrator General is the only exception in that regard, because we don't necessarily get paid or we're not remunerated except for that issue of that what Mr. MITI just mentioned, this 5% charge of what you levy against an estate for carrying out the work as Administrator General, and which is also particularly why I believe the law designed it that the Administrator General is a last resort as far as administering estates. Because some estates that you deal with, back to your earlier question about the kinds of people that come to see us, what kind of clients that we deal with, it's all manner of people, different income groups and so on and so forth. So you have estates which are well endowed financially. You know, someone died having left 10 houses, 500,000 kwacha
Mr. Kalumba, I would like you to hold your thought. I also want you to help me even bring into perspective when you say estates, so that people can understand what you were referring to when you talk about estates. And you can even give me a breakdown of the stages in terms of the income brackets, so that we can understand. Sometimes there are those who own big estates, but they are also especially at community level, so that we understand the various categories there.
Okay, that's a very good question, and the word estate in this regard really it's really just a fancy word created by the law to explain a person's assets and liabilities. That's really what it is. Of course, when people think about estates, by definition, it could apply to different things. You know, maybe talking about an estate, in fact, in terms of real property or whatever it is. But when we're talking about administering estates or deceased estates, basically you're talking about when someone dies, what they are worth as far as their asset base, what they owned, and as against their liabilities. So you may have someone who died having left assets worth, 500,000 kwacha, and they owe 450,000 kwacha. So basically their net asset value would be maybe 50,000 kwacha or something like that. And you may even have situations where somebody died having left 10 cars, 15 houses, and all kinds of things, but debts through the roof, which go beyond what they own, which of course would render that an insolvent estate, basically an estate that owes more than it owns. So when I speak of estates, I'm basically just saying the sum of one's what they own and what they owe. And then as far as income brackets, excuse my drifting off into that, but I was just basically saying that individuals die in different circumstances. Some may die having left a lot of assets and they owe less than they own, and some may die not having left so many assets. So you may have estates. When I say a small estate, basically an estate which someone may have not left so much or assets worth so much money. Maybe there's no real property, there's no house, there's no what, and that kind of thing. And then you come to the Administrator General and you're hoping the Administrator General is going to administer your estate. And then we have to get 5% of that. So really, the law designed it to protect individuals, to protect estates. We are supposed to be a last resort, not the first resort as far as administering an estate. The primary work that we do is to try and guide and help people, to advise, guide people on the law, and so on and so forth.
I know that there are many administrators, even as we speak. But would you be in a position, for instance, if someone has been appointed as to administer an estate, would you be in a position to provide education to such a person to say, okay, this is how you would manage the affairs according to the responsibility of being given? Do you also provide that service to the people?
Yes, as I was saying earlier, our primary work is really consultative. So when say for instance, you have an individual, sometimes you have an administrator of an estate coming to see us with a problem. Or it could be an affected family member, some beneficiary who's come to see us with a problem. We'll listen to that problem, but at some point we would have to call for what we call a consultative meeting. So having listened to this one individual complain about how their auntie is stealing money for the estate and not giving to people, or whatever the case may be, at some point we have to hear auntie's side of the story, we have to hear everybody, we have to sit down with the rest of the family, and that is what we would do in what you call a consultative meeting. And that is also the opportunity to guide, coming back to your question, what an administrator should do, or generally just how an estate should be administered. These are the steps you should follow, these are the rights, this is are the duties, that kind of thing. We are there to educate.
Yeah, but because like you say, we see in various stories we have covered, especially in Kanyama, people would say, because I'm an administrator, they feel entitled to say, an administrator, and I will tell you how much is entitled to you, and you don't think I can manage this money without getting a cut.
Of course, that comes back to what we were saying earlier on about the 5% and whatever, and why we're saying we, as Administrator General, the Office of the Administrator General is the exception, only exception, because the general position is that an administrator is not paid to do his work. You may have, for instance, a situation where someone has left a will, and in the will, I appoint Mr. MITI to be my executor, to administer my estate, and I may gift him with some kind of remuneration or whatever. That's something personal that I've decided to award to him as a gift. But generally, the law does not prescribe any kind of remuneration to an administrator.
First of all, I know you did mention something pertaining to the importance of a will, but you just talked about how whether one leaves a will or they die without having prepared one. But how significant is the aspect of ensuring that you ensure that you put a will in place, and how can people go about that process?
Well, as far as the significance, I really can't stress the importance enough. The fallout, unfortunately, and this is something that Mr. MITI, of course, can attest to. He's worked with for the department for a very long time, longer than I have. So he can tell you a lot more about even the kind of experiences that we have dealing with families who come with problems. People, who are brothers and sisters or mothers, daughter, whatever the relationship, people fight. People disagree, people tend to not see eye to eye on aspects of, administering estates and that kind of thing. And so, at least in theory, it's a nice way to secure a situation under which there's no question marks as to what is supposed to happen when one person dies. So if you happen to break that down in a will, to say, when I die, I want this house to go to such and such, I want my firstborn son to get this, I want, you are at least helping to try and alleviate the chance of people fighting or people grabbing things that they feel they're entitled to, because there's a document that is clear, signed by this person, saying that this is what I want done, with my assets. Now, as far as how people can go about doing that, of course, our office is available to guide and advise on matters of that nature. But of course, people go to seek legal help from whichever lawyers private lawyers or the legal aid for those who can't afford private lawyers. The aspect of writing a will, of course, has certain issues that are, peculiar to the law as far as how a will is executed and that kind of thing. But our office is available, of course, to advise and guide on those kind of things. But for this forum, we just want to stress that it's important for people to at least make the effort in their lifetime to write wills.
Mr. MITI, just you can add to that conversation.
Yes, the significance of preparing a will is, you have talked about property grabbing. So this disease, the syndrome of property grabbing, is reduced by introducing a will in it, in the sense that people feel they deserve something from the estate. You, when you are living, you decided which people should benefit, which people you treasure most in your life, and you think they should benefit from your estate. That is departing away from the Intestate Succession Act. Because the Intestate Succession Act, it has set a standard that the beneficiaries should be your family, the surviving spouse, children, parents, and dependents. So if there is someone left out of this grouping of, I've mentioned, these 4 categories of beneficiaries, and there is someone you want to really appreciate, you want to give something from your estate, then better put it in a will so that this person benefits from your estate. But if you do not include the name of this person who is not part of the categories mentioned, then this person will not benefit. These are people who come now back to say, I contributed to the well-being of the deceased, and I feel I must be given something from the estate. So they end up grabbing property. But then if they're in the will, you reduce the syndrome of property grabbing.
And I know Mr. Kalumba did partly touched it, but how can one prepare a valid will that cannot be challenged, especially by the court, so in the course of by someone to say, no, actually this is not a valid will, it does not meet the standards, and you just fabricated this?
Yes, the law requires that this person, at the time of preparing a will, he must be sane. He must be of sound mind, that he must know that he is preparing a will, not someone who is gone berserk and he prepares a will. That may be challenged. But most important, a will must be witnessed. And the people who must witness that will must be present at the same time that the testator is signing this will. So the most important issue is people must be present to witness the execution of your will. Then that becomes a valid will. But when you write a document just like a letter, I give my cattle to Mr. So-and-so, then you end there. That is not a will. It is your wish, how you wish it would have been done. But in the eyes of law, it does not qualify as a will. So a will must be witnessed for it to be valid.
So you need someone to witness it.
You need 2 people to witness a will, and yourself, the the testator, you must be present, and those people are not witnessing the contents of your will, they are witnessing your signature.
But where can one also keep the same will, and how do I ensure that it is safe?
Yes, a will can be kept anywhere. It may be kept with your church. It may be kept with your bank, especially your bank, and you may keep it at any safe place that you feel it's a safe place where it cannot be put to waste or lost. So
you can also just to add on,
yes,
you can also lodge your will with the court, with the High Court. I believe with the probate registry. I believe. I think or with the Administrator General.
Yes.
Okay, quite interesting there. But we've talked about almost everything there now. But we also have to understand what are some of the teething issues, what are the challenges that affect this important department we have in our country.
As far as, just to be clear?
In its administration and to just run effectively and achieve its mandate as enshrined.
Well, I believe we are well equipped to carry out our work as far as the legal framework, because like, as we were saying in the beginning, the office is an office created by statute. Yes, so what exactly the office is empowered to do is provided for by statute, and of course in that regard we are well empowered to carry out our work. Of course, the Administrator General, as far as presence, we are mainly situated here in Lusaka. There was an office, I think, in Livingstone at one point, which has been since closed down, I believe, and then there was also one in Dola. But suffice to say, the office of the Administrator General is not spread out, as across the entire country. You don't have an office of the Administrator General in every district, in every province, and that kind of thing. So as far as trying to reach, because we deal with estates all over the country, and as far as reach, the work, of course, our office would entail the need for us to, of course, reach all these different places, to physically inspect all these different places where estates, are found. So in that regard, of course, you may have a challenge or two here and there. But as far as the framework for which we need to operate, of course, we are well empowered.
Interesting. Mr. MITI, but what sort of awareness are you creating for this important institution so that most Zambians can be aware and be able to access your services?
Yes, that's like Mr. KATELE has stated. We have a challenge in the sense that a limitation to accessibility to our services by members of the public in other provinces. People are made to travel to Lusaka to seek services from the Administrator General at a high cost. We have tried in the past where we used to exhibit at the agriculture show in Lusaka, and at trade fair, and then the agriculture show in Livingstone, but finances have really limited our operations in terms of publicity. We are not able to stretch our services to other provinces. Just like we say, there is a challenge, also the challenge, about the act. A number of Zambians seem not to be aware of the Intestate Succession Act. In the past, before 1989, what was being practiced was customary law. And people in the remote areas still believe that customary law still operates. That is a challenge, and that is where property grabbing comes from. So after the enactment of the Intestate Succession Act, there came need to sensitize the public that customary law does not exist. What is there now? There is Intestate Succession Act, which is the Zambian law, uniform Zambian law, which applies every party of Zambia, every corner of Zambia. Is one law that applies so that the people do not victimize the beneficiaries of the estates. So we have a problem really to sensitize the public out there because we are limited by the finances.
Interesting. Before I let you go, gentlemen, I just want to just give me this message. What are the consequences of property grabbing, Mr. Kalumba?
Well, property grabbing, as Mr. MITI just pointed out, is a problem that has existed in our country for a long time, for as long as we can all remember. Unfortunately enough, the law does provide remedies for people who are victims of that kind of thing. And I think the important aspect to mention, which comes from our law, is the individual or the person who has been appointed as administrator is the only person that who is empowered by law to deal with an estate. Okay, you and you alone are empowered by law to deal with the estate, whether it's to sell property, to withdraw monies from banks, or to collect a pension from a former employer, or whatever the case may be. So anyone who does not possess this authority and comes and deals with the estate is actually committing a criminal offense. And the term is intermeddling. So property grabbing, if we are to use the loose term, is a crime. It's a crime punishable by law. And so we want to take the time to encourage members of the public to not to refrain from this kind of activity.
Mr. MITI?
Yes, I think property grabbing has been minimized in the sense that a number of NGOs have actually come up to sensitize people out there where we cannot reach. And again, very instrumental it has been the victim support unit. People have known their rights and they are now using the victim support unit of the police once there is that property grabbing. And there's been sanity of late. Very few cases are coming up for property grabbing, and it's a step in the right direction.
Your concluding remarks there?
Well, just to thank you again for having us, and coming back, of course, to what you had earlier said about challenges and what Mr. MITI had alluded to. Definitely, just to wrap it up, we've definitely had a challenge as far as people getting to know what our office does. People knowing more about the existence of our office. I mean, we were chatting about that, I think, off air, about how a lot of people don't know about our office and that kind of thing. And so thankfully we have embarked on this campaign to try and sensitize the public, as we are doing right now. And the Ministry of Justice, of course, has an exercise that is on coming up for sensitization. So it's an ongoing process. So we would like to encourage members of the public to keep asking the questions, come to our office. We've given, of course, our address, Kent Building, New Kent Building, 2nd floor. Please feel free to walk in with your questions and your problems as far as your administration of estates and that kind of thing. For those, of course, who are not privileged to get, help, legal help from our private lawyers out there. Yeah. So in conclusion, I think that's what I'll put to the members of the public. I'm just hoping as many people as possible are watching this program and learning a thing or two.
Mr. MITI, would you also want to conclude?
Yes, I think a lot has been summarized by Mr. Kalumba. We are thankful for this program and we're looking forward to many more programs to come. And we hope that will help us also to sensitize the public in the near future.
Thank you very much. Well, our dear viewers, we've come to the end of our discussion today. Quite an interesting topic addressing issues pertaining to wills and property grabbing. A number of issues have been discussed. You can still follow this program on our social media platform or on Facebook and just listen for yourself. You can learn one or two things. And just now, this is where we get to say our goodbyes. This in conversation have been having a legal principal legal officer, Mr. KATELE M. Kalumba, and senior examiner and estates officer, Mr. TITUS MITI, and together we have had a good conversation. Until next week, when we come with another episode of the People's Verdict, this has been Patrick Soko. Stay tuned and keep it on KANE TV.